Dpa30083 Company Law, presented by Dpa30083 and Haifa Atira. We're going to answer question number 3. Explain compulsory winding up under section 465 of the Companies Law 2016.
Assalamualaikum and hi Madam Mariana. My name is Fatin Nurwahida binti Arshad. My matric number is 01D8022F1040. Today, me and my friend will explain the compulsory of winding up under section 465 of the Companies Act 2016. The first is section 465 subsection 1 paragraph A. The company passes a special resolution that the company is to be winding up by the court. For example, where there is a commission of fraud, the company may wish to go for compulsory winding up in order to invoke the court's power under section 503 of the Companies Act 2016 to order a public examination of its officers or any person concerned with the promotion, formation, trade dealings, affair or property of the company. Next is section 465 subsection 1 paragraph B. The company defaults in logging the statutory declaration under section 190 subsection 3. This ground is only applicable to public companies pursuant to section 190 subsection 3 of the Companies Act 2016. A public company is required to log with the registrar a statutory declaration. Next is section 465 subsection 1 paragraph C. The company does not commence business within a year from its incorporation or suspend its business for a whole year. A private company can commence business immediately upon its incorporation, but a public company must comply with the requirements of section 190 subsection 3 before it is entitled to commence business. Generally, to winding up a company on the ground that it has failed to commence business within 1 year from its incorporation, the petitioner will have to show the company has no intention of carrying on business. If the company can satisfactorily explain why it did not commence business within 1 year, and the majority of the members do not wish the company to be winding up, the court may refuse to grant the winding up order. For section 565 subsection 1 paragraph D, there is no member in the company. Pursuant to section 9 of the Companies Act 2016, a company shall have at least one member. If a company has no member, a contributory or a beneficiary may petition to winding up the company under section 465 subsection 1 paragraph D of the Companies Act 2016. That's all from me.
Assalamualaikum, my name is Haifa Atira binti Muhammad Firdaus. My matric number is 01D8222F1051. So next, according to section 465 subsection 1 paragraph E of the Company Act 2016, the company is unable to pay its debts. This is the most common ground to compulsorily wind up a company. Section 466 subsection 1 of the Company Act 2016 provides 3 circumstances where a company will be deemed to be unable to pay its debts. The first circumstance is if a company owes a sum of money exceeding of the minister has prescribed and a company sends a notice of demand asking for the payment. The company has 21 days to either pay the money or make a deal with the creditor so that they will get their money back. Next one is if the court orders the company to pay a debt to creditor, but the company doesn't pay or doesn't pay enough, and the court tries to force the company to pay, but it doesn't work out. The third circumstance is if the court finds out that a company can't pay, the court will look at all the money the company might have to pay in the future, not just what the company owes. The court will check company's financial position to see if the company is really in the trouble. According to Section 465, Subsection 1, Paragraph F of the Company Act 2016, the directors acting in their own interest. The company may be wound up by the court if the directors have acted in the affair of the company in their own interest rather than in the interest of the members as a whole, and the directors have acted in any other manner which appears to be unfair or unjust to the members. Now let's moving on to the paragraph G. Expire of term or dissolution pursuant to Constitution. A company may file petition to wind up a company. If companies will say it should end after a certain time or if a specific event happens, anyone involved with the company can ask the court to wind up the company. This is another way to end the company instead of doing it voluntarily. Next, according to Section 465, Subsection 1, Paragraph H of the Company Act 2016, just and equitable. There are various circumstances in which the court ordered the company to be wound up on this ground. For example, breakdown of quasi-partnership. It is when there is a breakdown in the mutual trust among the members in relation to the management or operation of the company. Other than that, operation. In cases where there is affairs of the company are being conducted in oppressive manner or unfairly prejudicial to some of its members. And that's all from me. Next, Alia will continue the presentation. Thank you.
Hi, my name is Alia Batrisha binti Muhammad Ramzi and my matric number is 01DA222F1058. According to Section 465, Section 1, Subsection I, the company has held license under the Financial Services Act 2013 or the Islamic Financial Services Act 2013 and that the license has been revoked or surrendered. The revocation or surrender of a license under the Financial Services Act 2013 or the Islamic Financial Services Act 2013 is a serious matter with significant legal, regulatory and financial implications for the company and its stakeholders. Next, according to Section 465, Subsection 1, Paragraph J, the company has carried on a licensed business without being duly licensed or the company has accepted, received or taken a deposit in Malaysia in contravention of the Financial Services Act 2013 or the Islamic Financial Services Act 2013. Carrying on a licensed business without proper authorization or accepting deposit in a contravention of the Financial Services Act 2013 or the Islamic Financial Services Act 2013 is a serious violation of financial regulations that can result in legal, regulatory and reputational consequences for the company involved. Lastly, according to Section 465, Subsection 1, Paragraph K, the company is being used for unlawful purposes or any purpose prejudicial to or incompatible with peace, welfare, security, public interest, public order, good order or majority in Malaysia, or Section 465, Subsection 1, Paragraph L, the Minister has made a declaration under Section 590. If a company is being used for unlawful purposes or activities prejudicial to public interest, peace, welfare, security or order in Malaysia, it represents a serious violation of legal and ethical standards with potentially severe consequences for the company and the stakeholders. So that's all from us. Thank you so much for listening.